Okay, so hello and welcome to this very brief lecture on civil liberties. It's really just going to be me trying to explain in a very short time some of the key concepts about civil liberties first, and then hopefully some time for civil rights. The key thing that I need you to understand about civil liberties is simply that uh, civil rights and civil liberties are actually a very intertwined concept. Both of them are involving constitutional protections from the U.S. Constitution. And we've talked already about the right to privacy, so I don't have to get into that again. So hopefully you all are somewhat familiar with some of the key provisions in the Bill of Rights. But the thing about the Bill of Rights is that it really didn't matter much to the entire country until something happened called the 14th Amendment. And the 14th Amendment is really the unsung hero of the Bill of Rights in some ways, because the 14th Amendment has several provisions. Two provisions that we're going to talk about today. One is simply the Equal Protection Clause, and the other is the Due Process Clause. So first of all, just to explain a little bit of the context of the 14th Amendment. The 14th Amendment is one of three amendments that were passed by Congress and ratified by the states soon after the Civil War. The Civil War had compelled the North to make sure that the South had certain conditions they had to fulfill before they were readmitted back into the Union. And one of those provisions was that they ratify all three of the amendments they demanded. The First Amendment, the 13th Amendment, was simply one that banned slavery. The 15th Amendment was one that didn't allow for discrimination against people on the basis of voting rights on the basis of race. So it just ensured that, at least for the duration that the Northern troops were enforcing it for those 12 years after the Civil War, that newly enfranchised black voters were able to participate in elections. The last amendment, the 14th Amendment, was the Equal Protection and Due Process Amendment. Now, I will say that if you look through the Bill of Rights, there is already a due process clause in the Fifth Amendment. And in the Fifth Amendment, there is a clause that says no one shall be deprived of due process of law by the federal government. Now, the 14th Amendment is a little bit different because it says no state shall deprive people of due process of law. We'll come back to that in a minute. The other one is the Equal Protection Clause. They were obviously very concerned that the Equal Protection Clause applied to all these newly freed people and newly enfranchised voters too. And you would think that this is what could have ended segregation and discrimination, particularly in the South, but it didn't turn out to be the case. In a case that came before the Supreme Court about 30 years, after the Civil War, called Plessy versus Ferguson, the Supreme Court allowed a kind of state of affairs to exist that we know as segregation today. They said in Plessy versus Ferguson, there was a case that had to be decided about whether state-enforced racial segregation was permissible under this Equal Protection Clause of the 14th Amendment. It turns out that they said, they ruled that as long as there were separate facilities and they were still equal, for example, different water fountains for different races, different bathrooms for different races, that as long as it was separate, they could still fulfill the separate but equal, they could still fulfill the requirements of the 14th Amendment. This was obviously overturned about 50 years later by a case you may have heard of called Brown versus Board of Education. Brown versus Board of Education took the language of Plessy versus Ferguson that the Supreme Court originated and said that no, today we realize that separate is inherently unequal. and because of that, we think that we rule that all schools in throughout the country, including outside of the South, need to be integrated with all deliberate speed. So all kind of state-enforced racial segregation was banned from that point on, although it's important to note that still today there is a decent amount of effective racial segregation in many public schools across the country, simply because of residential segregation and many other factors. But at least the purposeful segregation was banned after 1954. So that began part of the civil rights movement. But the important thing to remember about the linkage between civil liberties and civil rights is the easiest way to remember is that civil liberties have to do with the Bill of Rights and have to do with fundamental freedoms and also protections from government, whereas civil rights have to do with the right to participate equally in a free society. So that could be free from racial or ethnic or national discrimination or gender discrimination when it comes to voting or when it comes to equal treatment by the government. Let's see. So that's kind of the difference between the two. There are many rights listed and enumerated in the Bill of Rights, and one of them we talked about, certainly the right to privacy. And we've mentioned the right to free speech and the right to the free exercise of religion. But let me talk a little bit about the Due Process Clause of the 14th Amendment as well, and why this is all related. So the Due Process Clause of the 14th Amendment says that no state shall deprive anyone of due process of law, and the Supreme Court has slowly utilized that clause to mean that any and all provisions in the Federal Bill of Rights that used to only apply to the government means that they define due process as recognizing all of the Federal Bill of Rights at the state level. So that means that the right to free speech, the right to freely exercise your religion, the right to be free from cruel and unusual punishment, all of the rights listed in the Bill of Rights are also recognized as things that the states also have to abide by. So a process called selective incorporation has really made it necessary to recognize all the Federal Bill of Rights slowly over about a 150-year course of history within every state, and it's still going on today. Let's see. We've talked about several of the amendments, like the Third Amendment, the right against to be free from quartering soldiers in your home, the Fourth Amendment right against unreasonable search and seizure. We talked about the Sixth Amendment right, by the way. We haven't really discussed it too much, but the Sixth Amendment right to an attorney during a criminal proceeding. The right to not testify against yourself, that the Fifth Amendment discusses and provides for protection against. The final thing I'll say about all of these civil liberties and all the list of civil liberties that are mentioned in the Bill of Rights, and all the ones that the Constitution provides some cover for in terms of new rights, that the right to privacy, for example, is typified by, is that they all also have the protection of strict scrutiny that I mentioned a few weeks ago. Strict scrutiny meaning that the government can't take away any of those rights or protections unless they have a real a compelling state interest, which means they have to have no other choice but to do it, and it has to be very related to a compelling state interest, like national security. So they can't, for example, discriminate against people on the basis of race on a routine basis, but they could do it when it comes to national security. So, for example, this one case called the Korematsu versus U.S. that I believe I've mentioned in class a couple of times. Korematsu was one of thousands of Japanese American prisoners who were incarcerated for the period encompassing the U.S. involvement in World War II, because it was considered to be in the interest of national security, and it was directly related to the inability of the U.S. government to find out that the Pearl Harbor attack had been in the making, and had the benefit of intelligence that was probably gathered on U.S. soil, potentially by people of Japanese descent. So that's at least why how they rationalized Executive Order 9066, that put all Japanese Americans, as well as residents who were legal residents of Japanese descent, in internment camps that the U.S. government ran from 1941 to 1946. This really impacted, for example, the Sacramento Japanese American community, but it was largely restored after the Civil War, but urban renewal took away the rest. I would urge you to take a look at the California History Museum to take there's a really good exhibit about that there. Also, in terms of, so that's civil liberties, essentially you can take away, the Supreme Court ruled that you could take away people's right against racial discrimination if it was directly related to a compelling interest like national security. So Korematsu has never been overruled, and that's why racial discrimination still has really, really, it's a really high protection that it enjoys in constitutional protection in the U.S. Finally, I just want to mention that in terms of civil rights, the civil rights movement was begun really slowly with several different starting points that we don't need to go into right now, but among them, things like the Montgomery bus boycott was started by largely the NAACP with the help of people like Rosa Parks and Martin Luther King, and that was the beginning of really organized urban-wide, city-wide social movements that were recognized nationally. And it really culminated in the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And the Civil Rights Act and the Voting Rights Act are two different things. The Voting Rights Act of 1965 guaranteed that jurisdictions, municipalities, counties that had histories of racial discrimination in voting had to basically run by the federal government any and all changes to their voting laws, and that stopped in 2013 when they essentially said, when the Supreme Court ruled that such a restriction was no longer necessary. So the Voting Rights Act is in large part dead in the last 5 years, but the Civil Rights Act is still in effect. And the Civil Rights Act not only it kind of reinforces this right to equal protection at the governmental level, but it also requires that businesses that are places of public accommodation also have to be free and open to people regardless of race. And finally, in terms of civil rights actions, there's an important bit of history that your book notes that in California, the largely Mexican workforce in the agricultural sector was being deprived of basic kind of dignity, as well as, not to mention, equal pay. And the United Farm Workers, under the leadership of Cesar Chavez, ended up fighting for and winning many rights that culminated really with the not only his many kind of fasting campaigns, but also the grape boycott that saw like a nationwide boycott on grapes until the grape distributors decided to give people in their employ a little bit more equal treatment. So these kind of societal-wide actions that were organized by groups like the NAACP and the United Farm Workers, and not to mention the March on Washington for Jobs and Freedom in 1963, were all sort of organized by coalitions of labor unions and churches. And like the Brotherhood of Sleeping Car Porters, for example, they actually had a huge hand in the Montgomery bus boycott as well. Brotherhood of Sleeping Car Porters was a largely African American um, union that was considered one of the maybe the leading um, entry for African Americans into the middle class in the time before the civil rights movement. It was the job of them to essentially staff the luxury trains that existed and that you can read about at also another museum in Sacramento, the train museum that's considered the #1 tourist attraction in Sacramento. So some interesting local history that kind of ties into national history and national politics. So civil rights and civil liberties are very much intertwined because they're both talking about protecting groups that have been excluded from full citizenship in the past and the ability to be protected at the constitutional level as free from racial discrimination as well as deprivations of rights and liberties. So if you have questions about any of this, I would urge you to reach out to me sometime between now and next week when the final exam is. Otherwise, I wish you luck in studying, and I will see you in class on Friday.